morning, everyone. Welcome to the First District Court of Appeals. We have 4 cases up for argument today, and I am only going to be on one of the panels, the first one. Judge Bergeron will be presiding on the other 3 cases, but I'm going to go ahead and call all the cases and make sure the lawyers are here. The first case we have for argument is case number C230046. That's Reynolds versus Hamilton County Developmental Disability Services. Would the attorneys please state your names and your readiness to appear?
Scott Solomon on behalf of Hamilton County Developmental Disability Services and the individual named defendants. I'm ready to appear.
Ready to proceed. Okay.
Attorney Bucher on behalf of the appellant James Reynolds, and we're ready to proceed.
Okay, wonderful. The next case for argument, we'll take a break after your case for Judge Bergeron to take the bench. The next case is C230116, State of Ohio versus McConaughey.
Jonathan Daniel on behalf of Mr. McConaughey, and I'm prepared.
Sean Donovan on behalf of the state, I'm ready to proceed.
Thank you. The next case is C230220. It's Sanders and Associates, LPA versus Responsive Surface Technology, LLC, et al.
Bob Winter for appellant, Responsive Surface Technologies, LLC, and we are prepared.
Okay, great.
Good morning, Your Honor. Tom James here for appellant Sanders and Associates, and we are ready to proceed as well.
Thank you. And the final case to be argued today is case number C230149 and 150, Darren Warman versus Levanova Deutschland GmbH.
Louis Schneider on behalf of the appellant, Your Honor, prepared to proceed.
Thank you.
Frank Goldwasser on behalf of Tri-Health, ready to proceed.
Okay, great. Thank you.
Joe Weinberger and Dustin Rollin on behalf of Levanova, ready to proceed.
My understanding that you all are splitting time, is that correct?
Yes, sir.
Okay. All right. So we will start with the Reynolds case. Would you like to reserve some time for rebuttal?
Your Honor, I'd like to reserve 4 minutes for rebuttal.
4 minutes. I'll keep your time. You'll see the lights on the podium. You'll have, the yellow light comes on with a minute left of your initial time. All
Thank
right.
you, Your Honor. May it please the Court, Scott Solomon from Schroeder Mondrell, Barbier and Powers, on behalf of appellants, Hamilton County Developmental Disability Services, which I might refer to as HCDDS at times, and the individually named defendants. We've appealed the trial court decision in this case with respect to the trial court's entry on defendant's motion for summary judgment. The trial court entry failed to address defendant's assertion of statutory immunity under Ohio Revised Code Chapter 2744, as well as Revised Code 5123.61K. And in doing so, the court ultimately denied our asserted immunity, hence why I stand before you right now for this interlocutory appeal. This morning, I look back at plaintiff's response to defendant's motion for summary judgment, and again, confirm that plaintiff Reynolds never made any arguments in regards to all of the defendants' assertion of immunity under 5123.61K immunity.
Well, let me ask you, Mr. Solomon. It looks like the court never even, trial court not even address that issue or never got to the issue, and seemingly denied your motion for summary judgment based on its belief that there was a genuine issue of material fact concerning whether Mr. Reynolds was an employee of Hamilton County Disabilities. Do you want to address that? The fact that, number one, the court didn't address sovereign immunity, but then there was an issue as to, in the court's mind, why Mr. Reynolds should be considered an employee. Why don't we do it this way? Why don't you tell me why he should be, why he should not be considered an employee?
Fair enough. And first of all, I will state, I don't want to waive the argument, the fact that this argument that he was an employee and therefore, was an exception to immunity was never made in the trial court level. So it should be considered by this court now, pursuant to Flans v. Cincinnati. But assuming it's going to be considered by the court, I'll go ahead and address that. But even then, he's alleging he's not entitled to, or defendant Hamilton County, the political subdivision, is not entitled to 2744 because of an alleged employment relationship, which would trigger 2744.09B, which would remove applicability of the chapter of its, to defendants. But the defendant admit in his testimony that he was not formally employed by Hamilton County DDS. And that's really the only reason. He cites in support of his position that he was an employee to Ohio Administrative Code 5123-1702 for the contention that he was an employee of Hamilton County, or HCDDS.
Well, does he admit he was an independent contractor in some capacity? I thought he did admit that.
I know I don't know that he necessarily admitted he was an independent contractor. He filed tax returns in 2016 and 2017 that stated he was an independent,
Right, okay.
self-employed person. In this case, when he was working for Array of Hope, who was the provider in this case, he was not only a DSP, a direct service provider, he was also the CFO, in charge of the finances, in charge of scheduling, hiring, firing, but yet he, getting back to that, he points to the administrative code for the contention that he's an employee because there's a definition in that code that talks about, who a developmental disabilities employee is under that rule.
Is there anything on the record showing whether Array of Hope or the other organization, which is slipping my mind right now, whether,
Perfect Circles?
yes, whether there is any funding from anywhere other than Developmental Disability Services?
There was never any payments made by the Developmental Disability Services. In fact, the reasons these were all made by Medicaid.
Oh, okay, okay.
And so there were no payments. He's never
But
signed.
was there another client other than, that's everything, I understand that the funding came from Medicaid, but was there any other source of income from that other than?
Not that I'm aware.
Okay, thank
I think
you.
that it was all about services provided to these clients under waivers. We're asserting immunity here. The only reason I'm here today is because it's immunity, an interlocutory appeal. Luckily, in 2744, they define specifically what an employee is. In 2744.01B, it says employee means an officer, agent, employee, or servant, whether or not compensated or full-time or part-time, who is authorized to act in within the scope of the officer's, agent, employees, or servant's employment for a political subdivision. In this case, HCDDS is the political subdivision. At no point was Mr. Reynolds ever acting on their behalf or authorized to act within the scope of the political subdivision. And therefore, I'd say I think other things that he talks about, he did not work directly for HCDDS, did not receive any payments from HCDDS, did not sign any policies for working with HCDDS prior to working with Array of Hope. He testified the wages he earned were paychecks payable to him from Array of Hope at Hamilton County DDS. Where I talked about the tax forms, which he filed, self-employed. Array of Hope, he testified, had its own internal policies, employee policies that and really he just complied with the rules and regulations of the DODD, the Department of Developmental, which he had to comply with. And then there are cases that specifically address this issue. In Wade Harrison versus Franklin County Board of MRDD, it's a case out of the 10th District in 1998. They held that the plaintiffs who provided waiver services to developmental disabled adults, services exactly at issue in this case, were not employees of that political subdivision. And the rationale included the fact that the plaintiffs never received any payments for waiver services directly from that political subdivision. They were individually responsible for all their expenses incurred, same as the situation here. They paid all their own bills. They could hire and fire whoever they wanted. There was no plaintiffs had to carry liability insurance and were responsible for fulfilling the requirements and goals set forth for each customer. And it talks about in that rationale as well that the plaintiffs in that case filed tax forms which would be applicable only to self-employed employees as well. The court, in fact, specifically rejected the argument that an employer-employee relationship was established because the political subdivision oversaw the program, which is what was occurring in this instance. Developed the goals and requirements for each of the clients and supervised the waiver program, which is exactly what happened in this instance. And was the relationship between HCDDS and Mr. Reynolds at that point as well. And they said that this is because the goals and objectives set forth by the political subdivision were merely the guidelines to be used by plaintiffs in successfully completing the waiver program. And so I would attest that the same rationale happens and is applicable to this case. In Williams versus Richland County, that was another case where plaintiff was the owner of a company that, among other services, provided housing and transportation to special needs individuals. In upholding the motion to dismiss for failure to state a claim, the court found that the plaintiff was not an employee of the political subdivision. That the rationale in that case also indicated that the agency did not retain control over how plaintiff, with a vehicle conducted the transportation duties. Similar to here, there was no direct oversight of HCDDS of Mr. Reynolds, just making sure that the compliance and generally was occurring with respect to these clients, these plans that were on the waiver services, I guess, that were being provided.
So did you start this off by saying that this, whether he's an employee or not, was waived, it was never argued below, and we shouldn't be considering it on appeal?
That's another one of my arguments as well, Your Honor. And I think, in fact, in my brief, I specifically cite to a case, Abdallah versus Alexa, wherein the appellate court held that a plaintiff had waived the right to assert 2744.09B by failing to raise the argument at the trial court level, which is exactly what occurred in this instance.
If that's the case, and if we would agree with you, what are you asking us to do? Just to send this back to the trial court to consider the sovereign immunity issue?
I would say that we would be to award immunity. I mean, I think the fact that they had their chance to raise immunity because they failed to meet the reciprocal burden of showing that there's a material issue of, question of fact as to immunity. They don't get a second bite at the apple, so to speak. The judge
didn't even address the issue, though. I mean, wouldn't it be better for us to send it back so that he could look at the issue?
Well, I would say in the interest of judicial economy, it would make sense to go ahead and address this now. I mean, this is 2017 is when all these things happened. In 2019 is when the case was filed. I think, if the case law holds that immunity should be addressed as quickly as possible,
Let me ask you, Mr. Solomon, I'm sorry to interrupt you, but aren't there issues of punitive damages and maybe not from your side, but from attorney's fees as well that need to be addressed?
They do talk about the fact that punitive damages are allegedly, that was not addressed by the court as well. That was not refuted because we raised that as in our summary judgment motion saying that they were not entitled to attorney fees and punitive damages pursuant to statutory 27, I think it was 0.05B, specifically states that political subdivisions cannot have punitive damages assessed against them.
Isn't that a little premature, though?
Well, whenever I can get rid of a claim, I think as a defense attorney, we try and get rid of those claims. But I think that the fact is it's not premature because they also didn't address the exceptions. They conflate the fact that with respect to a political subdivision under 2744, there's one way of establishing immunity and defending it. And then on the other side, with respect to the individual employees who are named individually in this case, there's a different way, right? There's a 2744.06A. I may have gotten that mixed, but there's a different way to go ahead and establish whether or not there's immunity that's applicable. And they only addressed with respect to the individual employees. They did not even attempt to set forth one of the 5 exceptions to the general cloak of immunity that is granted in 2744.02. So I think that they haven't even addressed that.
You talk about a second bite of the apple, but if it was just remanded for the trial, I mean, not for additional briefing necessarily, obviously, but for the trial judge to just decide the immunity question based on what was presented, wouldn't that be a more prudent way to go?
I still would say that we would end up back here again, because if they did or did not deny or grant immunity, we'd be right back in front of you guys and looking to you again for your interpretation, because it's a, MSJ, we get de novo review on some level, so. I think it would probably be best served here. And we haven't even talked about the other immunity that's issued, right? That wasn't talked about at all by anybody.
And you are at your time if
Okay.
you want to reserve 4 minutes.
I just want to make sure I get all my immunity addressed.
Okay.
Thank you, Your Honor.
Good morning. And please the court, Tony Bucher on behalf of the appellee James Reynolds. At the heart, this case is a case about race discrimination and retaliation in employment. And in lieu of, I know you all are aware of the facts of the case. I know you've read the briefs. Largely, we'll stand on those briefs. But I do think one of the questions that came up was Mr. Reynolds' status as an employee. Yes.
Before we get to that, I'm sorry, go ahead.
Yeah, before
You have
we
the same
get to that,
question,
can you address the fact that the trial court did not even mention statutory immunity and, did not consider that, or maybe it did consider it and just didn't put it in the decision, but can you address what we're supposed to do with that?
I understand the trial court's opinion was very, not very detailed. I think that's the nice way to say it. So it's not real clear what was being addressed by the trial court and what was not. And so if there are specific issues that need to be specifically addressed by the trial court, then I think you're correct, that it probably needs to go back to the trial court to make those decisions. My understanding, however, in sort of reading between the lines, if you will, the trial court's opinion, is that even as it relates to those issues of immunity and, well, the issues of whether or not he's an employee, that there are questions of fact. Frankly, I think that ORC 27, or ORC 5123.081 specifically defines an employee as a person employed in the direct services position by a provider or a subcontractor. ORC 5123.081A7 then defines provider as a person that provides specialized services to individuals with developmental disabilities and employs one or more persons in direct services positions. A Ray of Hope was unquestionably a provider. There can be no dispute about that.
Was this raised below, before you get too far into explaining why he's an employee? Did you raise this issue below?
Your Honor, I'll stand by the briefs that were submitted. I believe that the issue was addressed, and I am going off memory.
Because you're arguing on appeal that sovereign immunity doesn't apply because he was an employee, right?
Correct. Well, and specifically, sovereign immunity states that it doesn't apply in situations arising out of employment. And both the defamation claims and the discrimination retaliation claims clearly arise out of this.
But you're not sure if this was raised below, but for the trial judge to consider?
I believe it was, Your Honor, but I can't cite to a specific, section of my brief or.
Okay.
Let me ask you, Mr. Bucher, besides the statute you just cited, are there any other arguments you have in favor of Mr. Reynolds being deemed an employee of Department of Disabilities?
I believe that those statutes directly address it.
Okay.
And then the other issue, and it was briefly addressed by Mr. Solomon in his argument, is the issue of control. Now, he seems to suggest that the HCDDS did not have any control over his employment. However, in this particular case, they directly they ordered him to be suspended from providing services for clients of HCDDS. I don't know how you can exhibit any more control or exert any more control over an individual than prohibiting him from doing his job. So in that respect, if you go straight to that sort of common law control agency sort of principles, I think that they clearly would qualify as a joint employer.
But he was still, despite the fact he was suspended, he was still being paid by...
He was not. Well, no, you're right. He
but
was
not-
briefly,
right,
yes.
but, okay.
They were, the Array of Hope was suspended
Right.
shortly thereafter.
All right, and only just to clear up something, in the perfect circles was, my recollection was it was totally separate. They didn't get any, what I'll call government money, but it was designed, it was a boxing club or something like that. Is that right or wrong?
You're a little off. They did get money from
Okay.
Medicaid money for that. What it was is that there's a difference between day services and services that are provided for individuals, like day-to-day living things. Mr. Reynolds he started, just a little background, he started with HCDDS providing services for a single individual, where he was providing round-the-clock care for this individual. And then he teamed up with A Ray of Hope and then expanded his sort of practice to include this Perfect Circles day program. That was a day program where other individuals who weren't necessarily qualified to get services 24/7, they would come into this facility where they would do programs, music or exercise, whatever. And that's sort of what a Perfect Circles was, but that was a part of Ray of Hope and what the services they provided.
So do you dispute that Mr. Reynolds was an independent contractor?
Mr. Reynolds, A Ray of Hope would have been the independent contractor.
Okay, but you're saying was he not employed by the Ray of Hope?
He was employed by A Ray of Hope. But
Okay.
under the statute, he would qualify as an employee because A Ray of Hope is a provider.
So he was not so Ray of Hope was but he filed taxes as an independent contractor, right?
It was the way his relationship with A Ray of Hope was, he was paid through A Ray of Hope.
He was an independent contractor to Ray of Hope,
Yes,
and Ray of Hope was the independent contractor to the government.
correct. I think yes.
Is that the
Yes.
way you're looking at it?
Yes.
Okay.
But in that respect, like I said, because he worked for that provider and was paid through that provider, I think under ORC 5123081, he would qualify as an employee.
What about under 294401B? There's a definition under RC 294401B.
But I'll just defer back to, I think because 5123 expressly applies to HCDDS, the welfare positions, I think that's the definition you have to.
So we would ignore the other definition of employee.
I think
under
that I think that 5123, the definition there is enough.
Okay.
But again, and again, the brief, I'll stand on the brief, so I don't want to unnecessarily use time that I don't think is, if there are no specific questions. But again, I go back to, this case, it all started because Mr. Reynolds had the courage to stand up and confront people who were discriminatorily comparing him to another black individual who was charged with crimes. He had the nerve to stand up and confront them for that discriminatory practice, and thereafter they began this path of sabotaging his career. Again, what's important in this is this all started with an unusual incident investigation. These investigations are supposed to take 30 days. This investigation didn't get concluded. No results came from that until nearly 2 years after it began. In those 2 years, he was suspended from practicing or from doing the work that he did. They effectively ended his career and blackballed him in the process. So, again,
There's no doubt that there's concerning allegations in this case, but the issue of sovereign immunity has to be dealt with. And it doesn't seem like the trial court did it. Now your opposing counsel is saying, well, we don't even need the trial court to deal with it. This court can deal with it. But someone's
don't
got to
see how
deal
it
with
can't-
that issue,
Oh,
right?
excuse me, and I apologize. I don't see how it can't be dealt, it has to be dealt with.
Yeah.
And I think that probably the trial court should be the appropriate spot for it to start at least.
So you would agree that the trial court didn't address sovereign immunity in his opinion? I mean,
Not specific, the opinion is the opinion, and it's very brief, and it's.
we can't read it that way.
Sure. Like I said, I think in between the lines, I think you, just by saying that there are questions of fact, the trial court probably impliedly suggested that he believed that he was an employee and that sovereign immunity didn't apply. And that the trial court went straight to the fact that there were questions of fact about whether or not it was discriminatory or retaliatory conduct. So, yes, I mean, I think that that's because the opinion is so focused on those questions of fact. I think it could be impliedly inferred that he did go ahead and accept that sovereign immunity didn't apply and that Mr. Reynolds was an employee. So, thank you for your time.
Thank you. You have 4 minutes.
Your Honor, quickly, I would say that by not considering immunity, the trial court denied it. And I don't have case law, I can't cite the case law. I would not be surprised if there is case law out there that states that, but I don't have that at my disposal right now. I didn't know that issue was going to pop up. But that would be our position, is that it wasn't, even if it wasn't considered, we raised it. That's our duty, and whether the court considers it or not, it's a denial if they don't grant it. And even if they would have considered it and denied it, we'd be in front of you right now saying, hey, we're still entitled to it. And I think that you don't look to the Ohio Administrative Code to determine whether or not 2744 considers you an employee. You look, guess where, to the actual code itself, which defines employee, 2744.0B1, which in fact, I didn't get a chance to read this last time, but it defines employee. It specifically states in that definition that it does not include independent contractors. So employee means an officer, agent, employee, or servant, whether or not compensated or full-time or part-time, who's authorized to act and is acting within the scope of the officer's, agent's, employees, or servant's employment for a political subdivision. Employee, this is explicitly, does not include an independent contractor. Opposing counsel just admitted that he was an independent contractor. 2744, this exception that they're asserting doesn't apply, not that they raised it anyway in the lower court, but it doesn't apply even if you consider it today. And with respect to the administrative code that he cites as well, Rule 5123 -1702, it says the purpose. This rule establishes requirements for addressing major unusual incidents and implements a continuous quality improvement process to prevent or reduce the risk of harm to individuals. You go down to Section C, it has definitions. And at the very beginning, it says, for purposes of this rule, the following definitions shall apply. And that's when you get into, what he asserts defines an employee. That's only for that specific rule. That's not for 2744. 2744 talks about, what, and defines clearly, and you don't have to read between the lines on that, what employee is. And clearly in this instance, Mr. Reynolds was not an employee, and so 2744 applies, the immunity applies. And again, we get back to, we haven't even talked about the other issues of immunity, the immunity that that talks about the investigation of an MUI, which is another, I guess, section of immunity that the trial court did not talk about. 51, I think A3C was not even refuted by the opposing counsel in the response to summary judgment at the trial court level, and clearly the court didn't address that. They didn't say the words immunity in their decision, and they didn't cite any references to 2744 or the other statute that provided immunity. Unless you have any other questions, we would request that you consider this and grant immunity to the defendants with respect to all the claims.
All right, thank you.
Thank you.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. So we will, I'll have Judge Bergeron come back out on the bench, and the next case is State versus McConico.
Good morning, everyone. We're here on State versus McConaughey. Mr. Dameron, would you like to reserve any time for rebuttal?
I would like to reserve 5 minutes, Your Honor.
Okay, you may, very well.
May it please the court, my esteemed counsel for the state. Excuse me. This case is a simple case in my view, and I'm going to use the KISS method to keep it simple, stupid. The facts are very clear. Mr. McConaughey, my client, was driving a vehicle which was registered to his girlfriend, and she was unlicensed. And he's a black man, and she's a white woman, or she's a woman. And so the police officer ran the place, which is a perfectly legitimate thing. It's not even a search, and it came back that the owner of this vehicle was not licensed. So the officer, Deputy Cottle, initiated a traffic stop. And he stated this when he walked up to the car. I pulled you over because when I ran the license plate, the registered owner doesn't have a valid license, which I see you are not her now. So the reason for the stop was that the registered owner did not have a valid license. Once the deputy walked up to the car and saw the driver of the vehicle was not the registered owner, any reasonable suspicion of any criminal activity evaporated like a puff of smoke.
So, but what if, for instance, he did that and notices, a bunch of drugs in the car just in plain view? I mean, he clearly could then act on that.
Exactly. Yes, no doubt. I totally agree with you. He did not see that.
Right.
But yes, if that were the case, it would definitely be true.
But you're saying, just so I understand your position, that as soon as it was apparent that the driver was not the registered owner, he has to say, go on your way, sir.
That's my position, and also his position, in my opinion, of the Supreme Court of the United States, Ohio, and appellate courts, the enlightened appellate courts of Ohio. In fact,
I don't know if we're included in that or not.
You are. In my opinion, you are. No, in fact, one court. I'll move on. So I want to be brief. So I first want to I want to keep it simple, and I tried to write a good brief and so I'm going to kind of summarize that, but try to be.
Can I ask you a question first?
Yes, please do.
Okay, so the, give me just a second, let me find the name of the case. So the Chatton case was the Ohio Supreme Court case that you're relying on.
Correct.
And, there was language in there that supports your argument. But then 9 years later, the Ninth District came out with the State v. Graves case, which very similar facts. In that case, the court ruled that the officer had the right to ask for the identification, and that and agreed that the trial court properly denied the motion to suppress. Here's what I'm getting at here. So State v. Groves, I believe that the defendant asked the Supreme Court to review that, but it didn't, even though it was 9 years later. What should we do with that?
That was a appellate decision from not the first district, which I don't believe is as well reasoned as the appellate districts that agree with me. So I think that you should take it into consideration, but I think my argument is a better argument, so you should disregard the argument and buy my argument, basically. And I might add that in State versus Jabrell D.T. Lewis, which is 2022 Ohio 3006, which was just decided in August of last year, the court mentioned the arguments contra, mentioned Graves, the Graves decision, and what it found was, it said the Ohio, what it stated was that the rationale provided in these cases, the Graves case and I think the Metcalf case, is that is that once a vehicle is stopped, it is a slight intrusion then to ask for identification. The Ohio Supreme Court's decision in Chatton appears to be contrary to such a conclusion. Chatton specifically held that it was improper to ask for identification. Again, I think that precedence is precedence, and Ohio State and Supreme Court case law should take precedence. I want to go. I want to touch base on a couple of things. One is the left turn signal, which I think is vital.
Let me ask you about that, because I was getting ready to, Mr. Dameron. So your argument essentially is the police officer was lying.
That's true.
Okay, but the problem with that is that in the findings of fact by the trial court, they cite the fact that the court believed that your client made a left turn without a signal. So if we were to disregard the invalid license, doesn't the officer have the right, assuming he observed your client make a left turn without a signal, doesn't he have the right to ask for its identification? That's the first part of the question. Okay. To issue the ticket for the left turn, and then when your client provided the identification, it was false. So the first part is, may the cop ask for his identification to write the ticket for the left turn. The second is, may the trial court judge the credibility of the witnesses, given the fact that you're saying the cop's lying,
And my client lied too.
despite the fact that your client gave false information to somebody in North Carolina.
Gotcha.
Okay, so answer the first question
Okay,
first.
yes, Judge. If Judge Dinkelacker relied upon the fact of the left turn signal, I'd be sunk. I would lose this case. I don't think he did, and for this reason. If you look at the second page of his decision, on the second paragraph, he states, Deputy Cottle testified that he observed defendant, at that point the driver was unknown, make a left turn without a turn signal. So what the judge said in that statement, and one thing that the laws taught me is, and I try to be precise with my language, so he says that the deputy testified. He doesn't say that he believes him. He doesn't find that as a finding of fact. So that's number one. And then more importantly, when you get to page 4, in the penultimate paragraph, it says the court does, well, the bottom line is the court did not rely on the left turn signal to overrule my motion. What the court said was in the penultimate paragraph was the court must and does conclude that Deputy Cottle, in the course of performing his duties as a law enforcement officer, did not violate any constitutional rights of Mr. McConaughey. Deputy Cottle acted in a manner that allowed him to proceed with an investigation of the status of an unfamiliar vehicle in a high crime area, and that was, in my view, and what I stated in my brief, alternative fact number 2 was a drug investigation, but we're sticking with 1 right now, which is the left turn signal. And so what the court is saying, they relied on their decision, right in this paragraph, Deputy Cottle acted in a manner allowed him to proceed with an investigation of the status of an unfamiliar vehicle in a high crime, high drug trafficking area, the Van Buren Street of Lincoln Heights. The status of the driver who is driving a vehicle not owned by him, whose owner is not properly licensed. The driver hesitated to pull over after being signaled to do so, and the deputy said it wasn't that big of a deal. It was a slight hesitation. And why the occupants of the car exhibited a degree of nervousness. I mean, I'm nervous when I get pulled over by a police officer. All of these facts amounted to grounds to ascertain that Deputy Cottle was acting upon a reasonable suspicion that he was observing a crime or that criminal activity was about to occur. And then the two paragraphs up, the court, Judge Dinkelacker mentions the Brenlinger decision, and then he gets back in, he talks about again, unlike Deputy Cottle, where he's basically distinguished in my cases, who purposely followed an unfamiliar car from a high drug trafficking, high crime area, and then it goes on. It does not mention the left turn signal. And so in my viewpoint, Judge Winkler, the judge found that the deputy testified that he did not observe a left turn signal, but he didn't find that was a finding of fact, and he didn't rely upon that on his decision. So that's my long answer to your first question, and I got to be honest with you, I know, I forgot the second question.
Yes, so did I. I'll think about it.
Okay. And so I think that's a vitally important point, and I hope that I've conveyed that to you. And then the last part is the drug investigation. The trial attorney did a good job of cross-examining the officer about the left turn signal, but he did not do a good job of cross-examination the officer on the drug activity, and that was me. But I want to conclude with this for right now, anyway. The drug investigation. I want to turn to the prosecutor's brief. In which they basically say that what Judge Finkelhocker said, that this deputy had a reasonable suspicion to investigate a drug activity. And the court, so the state brought up a case of state batch chili, and what it says is the court found that failure to stop for 2 miles, nervous interaction, multiple statements as to who owned the vehicle, tinted windows, cargo car compartment in disarray, with blankets covering boxes, and a vehicle smelling of deodorizer, which provided sufficient means, versus my case, where they walk up and he says, this deputy testified that he knows this city like the back of his hand. He knows every car that comes in. And if he doesn't recognize this car, it must be a car in for the drug activity. How ridiculous is that? His only testimony was he saw this car earlier in the night, and it was in the dead end where all this high drug activity is. But he didn't testify. Anybody came up to the car. There were no occupants. There was no hand-to-hand, nothing. Just a strange car. Versus what the batch...
So this is a residential street.
Yes.
And there could be innocent explanations for this car to be there visiting a friend, visiting whoever.
People have everything delivered, food, somebody gets a new car, a friend visiting, and there's a million reasons why a car would be in this neighborhood, and just because this officer doesn't recognize it doesn't make it a drug car.
And you're at your time if you want to save 5 minutes.
Yes, I do.
Okay, thank you.
I apologize, I just had knee surgery.
Take your time.
Hopping around.
The fact that you're here is pretty impressive, frankly.
I'll be going home shortly after.
Yes.
All right, Mr. Donovan.
Good morning, Your Honors. And I think I'll start where Mr. Dameron started. I agree, this is a simple case. And this goes to your point, Judge Winkler, that the court found that there was a traffic violation, that there was a no-turn signal violation.
Did it actually find that, though?
Your Honor, I would think that certainly if it were going to find that that was not credible testimony, that it would have been normal, that it would have been prudent for the court to specifically find that by saying that.
Well, but I think we have this problem a lot in motions to suppress hearing, where the court may focus on one thing but not another, and I don't think we can presume one way or the other that the court made findings that it didn't make. I mean, the easy thing for the court to do if it believed the left turn violation would be to say, there's 2 grounds on which I'm finding that this was appropriate, A and B.
Absolutely, Your Honor. And as we mentioned in our briefing, as this court has reiterated numerous times, the court can be right for the wrong reasons. The focus of the argument below between both attorneys and the focus of the cross-examination, everything was on reasonable articulable suspicion. However, there was no need to go down that path. And I don't think that there's a need in this case. And in my mind, it belies logic that the court would find this obvious objective statement that I observed traffic violation not credible, but find the nuanced statements about nervousness and slightly slow to stop, and all the other facts that he did state when he was talking about reasonable articulable
Yeah, but he
suspicion.
didn't list that, and that was an obvious thing to list as he's chronicling all of the reasons. I hear you, I
Absolutely.
understand what you're saying, but we just can't supply a factual finding that the trial court didn't make.
Well, let me suggest that, I'm looking at the trial court's decision under Section 2, discussion, findings of fact. Second paragraph on the, it's like the second page, just reads, as the registration query was being processed, Deputy Cottle followed the defendant's vehicle for a short time. During that time, Cottle testified that he observed the defendant. At that point, the driver was unknown, make a left turn without a turn signal, but he lists that under his, the findings of fact. But are you, I'll ask Mr. Dameron if he's suggesting that we not consider that, because it's under the section findings of fact, and he goes on to conclusions of law. And in my mind, that he was just addressing Mr. Dameron's arguments under the Supreme Court case law. So tell me why I should not consider that.
I think you absolutely should consider it, and I think that the trial court fell victim to what, and I believe it was in the Chile, or however they want to pronounce that name. I apologize to that individual if I'm mispronouncing their name, but the court acknowledged that once more serious, once more, more serious in the traffic violation can excuse a forgetting about that and not mentioning it once you're focused on more serious matters. And I think that that's quite simply what happened in this case, is that the court started focusing on these other matters because that's the argument. And hey, the room prosecutor was making the same arguments. They were all discussing this reasonable articulable suspicion, and quite frankly, I think that it is there. I don't think that this ends the discussion. I think that it is there. But
Well, but I think Chatton
it's
is, Chatton is an obstacle for your position.
I don't believe that it is, sir.
Okay.
And in Chatton, the sole basis, the only basis for the stop is this mistaken belief that there was an invalid license plate displayed in the back. In all the cases that counsel relies on in supporting it, there's no independent rational basis. And I think this goes back, Judge Bach, to a comment that you were making and talking about. And I believe that the independent reasonable basis, and quite frankly, Judge Bergeron, your opening statement about if you see drugs lying around, you clearly have authority to investigate that. In Chatton, there was no reasonable suspicion. There was nothing other than, don't see a license plate in the back window, I'm going to pull that individual over. Here, we have all the factors that the officer talked about in terms of the, not only is it a
Yeah,
high-
but my concern about those factors, and I understand them, is that what that means then is that there's a different Fourth Amendment standard in a high crime area versus a non-high crime area, because I think what you're saying is that that makes this permissible to stop, notwithstanding Chatton, because he was in a high crime area.
No, Your Honor.
Okay.
I'm not saying that, and I also don't think that the generalized high crime area, if we're talking about the entire neighborhood of Lincoln Heights and this entire multi-block area that they're talking about is a high crime area, perhaps the court's concern. I think the court's concern is diminished when he says this specific cul-de-sac in a residential area, this specific block is the epicenter of drug trafficking in this area.
So people in that block have a lower...
And people visiting that block as well.
I understand, and I'm not saying that independently that it is a sufficient basis. I think we're coming back to the cases, and I apologize, the Graves case was not cited below. I'm not familiar with, and I think you were saying Graves?
Graves, correct.
Yes, and the Lewis case that counsel mentioned also was not raised below, so I can't specifically rely on that. However, in Metcalf, which is the other 9th District case, and there was an 8th District case, and the Illinois Supreme Court case that they rely on, where they say that when the driver of the vehicle is not the owner of the vehicle, than the minimal additional intrusion. And what I would present to your concerns, Judge Bergeron, is that I think it would be a different argument as to whether or not you could pull somebody over based on these facts. However, once we have that individual pulled over, then we can look at the totality of all these things. And certainly, the mere presence in a high crime area, the case law is clear. That is not an individual in and of itself, that is not sufficient to generate a reasonable articulable suspicion. However, when coupled with everything else.
Can you tell me, I've read the briefs, I've read the decision. I would just want to hear from you, what factors justified this?
And I would say that the justification is for the minimal additional intrusion after you've already got, because the entire basis, the entire scope of the motion to suppress was merely his authority to ask that question.
Mm-hmm.
Can I see your driver's
Correct.
license? Whether or not he can do that or not. We have not only a high crime area, but specifically this one specific block, this specific cul-de-sac. The officer's extensive experience with that. He says that he is in that area, and it's not as counsel says that he's testified that he knows every single car in Lincoln Heights. He said he's very familiar with this specific block. He visits that block when he's on patrol at least once every half an hour. So twice an hour over the course of a 12-hour shift, he's in this specific block. He sees an unfamiliar car parked at that location where most of the foot traffic and non-resident foot traffic, non-resident vehicular traffic is involved in drug transactions. Those are the issues that he raises. He then says that the vehicle is slightly slow to stop. Sure, nothing egregious. The officer even says that in his testimony. And then that the defendant and the passenger appeared nervous, and that the driver was not the owner of the vehicle. All of these facts, it is the totality of all of these facts. We can't read in isolation. We can't provide individual innocent explanations for all of these. The question is whether or not the trial court's decision was clearly erroneous, whether it was clearly a mistake. And the case law is clear that we in the reviewing area, and you as the reviewing court, we don't get to substitute for it. It's your own innocent explanations for these different behaviors. Yeah, it's possible that he was an Uber driver driving a BMW that was parked, and that it's possible. But it's also possible that the officer's suspicious. And so what I would say that the 8th District case and what Metcalf says is that, and this is to reconcile with the Supreme Court not taking it in and not addressing this issue, is that in those cases they're saying that not being the owner of the vehicle provides that independent reasonable basis. I'm not sure that I would go that far. I'd be happy if the court did. But once you couple that with the additional factors of where the car is coming from and the actions and the concerns that the officer had, you couple that with not being the owner of this vehicle being pulled over, the minimal intrusive nature of just asking for their ID when the vehicle is already legally stopped. And we all agree, there was a stipulation, vehicle was legally stopped. Absolutely had basis to legally stop it. Could he have stopped it if, as he's driving by, he sees that it is a man and it's not the owner of the vehicle? I think that's a different argument to be raised, and I think a much closer call. But in a situation like this, where the person is legally stopped, the officer did testify, while it might not have been the primary focus of his concerns in investigation, that concern about the vehicle being stolen also motivated his desire to ask questions about who is the owner of the vehicle and can I see your ID? And so it's, once again, it's the totality of the circumstances. And so I would suggest that in Chatton, to come back to your point, Chatton is easily distinguishable from this, because in Chatton, there is nothing else. Here, there are other things. I would not suggest that, I think a reading of an adoption of the Illinois Supreme Court case that counsel relies on, in which they say there doesn't need to be any other independent basis. Once you've already got him stopped legally, regardless of anything else, you can ask for his ID.
But that's
I don't think
contrary
that's
to, I mean, that's contrary to our Supreme Court.
absolutely. That's the point that I was making, Your Honor, is that I don't believe that that is consistent with Chatton. However, I believe that not being the owner of the vehicle, as the 8th and the 9th districts have said, and I think those cases can be read to say that that's providing your.
I'm going to push back a little bit on the 8th District case. In the Dowdle case, correct?
Yes,
That's the case that you were discussing from the 8th District? And in that case, there was, it was in a known drug area, and the driver drove away from the stop sign at a high rate of speed, suggesting that the occupants were trying to get out of the view of police. So that didn't happen here. There wasn't that factor where the driver saw the police officer and took off.
No, ma'am, that certainly did not happen in this case. I guess, the additional factors, it's kind of like in the recitation of what provided reasonable suspicion in Pachilli. It was certainly more than we had here and clearly provided it. I think that had that happened in this case, it would be a different issue entirely. So I'm not trying to say that it is directly spot on. I'm trying to interpret their decisions and make them consistent with Chatton. And I think that consistent with Chatton and with the 8th and the 9th District in other cases, that when there is an independent, reasonable basis, and I think that those cases are saying that it might even be a slightly reduced standard when there's already a legal basis for the stop to ask that additional one question: can I see your ID? And to establish, whether or not that individual has the permission to be driving is the issue that they addressed here. I don't think that in and of itself should be sufficient, but when coupled with everything else that was observed, and I just want to emphasize, we're not talking about over the Rhine as a high crime area. We're specifically talking about the corner of 9th and Sycamore as being a high crime area, and that specificity as to the location, this specific location, it's not a generalized high crime area. It's this specific location, this specific house, this specific cul-de-sac, and I think that is something that further distinguishes it from a generalized statement about high crime areas. I'm assuming I'm way past time.
You are, but.
If there are no further questions.
Great. Thank you very much.
Thank you.
All right, Mr. Dameron, you have your rebuttal.
Thank you. First off, my colleague is correct. I think I did state that the officer said something about knowing all the cars. That was an overstatement. His testimony exactly was most. It's my personal experience with working in Lincoln. This is page 27, line 7 of the transcript. It's my and this is Officer Deputy Cottle. It is my personal experience with working in Lincoln Heights that most of vehicle and pedestrian traffic on that street that are not residents or direct family members of residents are on that street to go there to buy and sell drugs. Again, I would ask you if you would look at the body-worn camera. I think it's very enlightening, and it really adds flavor to it. It's about a little over an hour long, and what it shows is the initial interaction, and it also shows Deputy Caudle with another officer searching the vehicle after the arrest, talking. They're there for over an hour. Never once does Deputy Caudle mention anything about a left turn signal or drug activity to his fellow officer. And I also want to point out, I think that the panel understood my the precise point about the turn signal, so I won't belabor it. But I will say that on page 32 at line 10, well, actually at line 7, the prosecutor asked, did you see any traffic moving or equipment violations on that vehicle when you were following or traveling behind the vehicle? And in response to that leading question, he says, I did not see the left turn signal being used. He doesn't say that Mr. McConaughey didn't use the left turn signal. He says he didn't see it. And I've kind of noticed in my life that when people aren't quite telling the truth, sometimes they just, that's the kind of a, well, I'll say I didn't see it and said he didn't use it.
So the very next question is, so you're indicating that when you observed the vehicle making a left-hand turn onto Shepherd, you did not see the driver activate a turn signal, and the officer answered correct?
Correct. That's true. And so I won't belabor the point, but I just want to say I think that, well, another question. I mean, I think if it was me, I would say, I watched him, he didn't use the turn signal, instead of saying I didn't see it. I think that adds some, but anyway, but it's a minor point. I certainly agree, and I hesitate to say this, but I feel like I must. I agree with my colleague that if the trial judge found the officer not credible, it would have been prudent for him to specifically find, I don't find your testimony about the turn signal credible. This judge is a fine judge, an honorable man, seeks to do justice, but he's never granted a motion to suppress in all his career, from my understanding, and I believe that this is as far as he could go. I don't think he could find it in himself to say this cop was lying. So when he stated in the body of his entry that the officer testified that he didn't see it and didn't say that I find that to be true, and then didn't rely on it in his conclusion, and I think that's as far as he could go.
You're both making arguments about factual findings that
Okay, well then I'll move on. I'll move on. I would also say, well, let's get back. Let's get to the bottom line. The judge found 4 things: the high drug area, driver not the owner, hesitant to pull over, and nervous. Of course, the Constitution applies in high drug areas. Driver not the owner. If you watch the body-worn camera, immediately he says, "I see you're not the owner," and he asks who the owner. My client says the owner's name. So it's not like he's a stranger stealing a car. Hesitant to pull over. The testimony was slightly so to stop, nothing majorly concerning or egregious. So what you have is a guy who's nervous when the cops pull him over. I don't think that's enough sufficient reasonable suspicion of a drug activity. So the bottom line is I believe that the panel should conclude that the trial court was wrong and decide my way. And I thank you for your time. It's always a pleasure and privilege to be here. Thank you.
Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.
One day I won't be nervous or shuffle paper.
It's okay. All right, our next case is Sanders and Associates versus Responsive Surface Technology. Morning, Mr. Renner.
Morning, judges.
Yeah, you may proceed. Would you like to reserve any time for rebuttal?
5 minutes.
Okay.
Bob Werner on behalf of Appellant Responsive Service Technologies, LLC. Judges, the issue that we believe is presented here is whether or not the trial court lacked personal jurisdiction over Responsive Service Technologies, LLC, to enter a default judgment because of bad service. Well, the underlying case is essentially a collection case. Mr. James' client rendered legal services, and we disagree with the amount and whether the amount was proper. 3 defendants were sued, including Responsive Surface. The trial court clerk served Responsive Services, or attempted to, in its corporate headquarters in Atlanta. And that's where the problems start. The return.
And so as best we can tell, the plaintiff and the clerk's office did everything right. This is just an issue of the post office not indicating the address and not obtaining a legible signature.
And the identity of the person signing. There are 3 things that are absent.
Correct.
Yeah, there are 3 things that are absent.
So this is more like a post office issue, not a clerk or a plaintiff issue, as best we can understand.
Well, once it came back, once this came back, I think Mr. James should have had service reissued and send it back to Atlanta. That wasn't done, and I will say that it eventually was done, and Responsive Service has filed an answer based on the most recent attempt at service upon my client. So, yes, it is that's the only fault I can put on plaintiffs and his counsel. It is, the trial court clerk did just fine. It's just, well, if you take a look at the return, I mean, at least they put COVID-19 on that last one, Judge. You can't even get to that here. As the trial judge ruled, well, after motion for default judgment was filed, the trial court ruled that my client was properly or duly served with process based on the trial TD number 7.
And there was also an affidavit, correct, from Mr. Taylor, in addition to, the address and the signature being illegible. There's also this affidavit saying that he was the sole person there and he didn't sign it, correct?
Right, because the fourth element is that the post office did get right was October 11th, 2022 was when the post office says all this happened. Well, we want to make sure that the court understands that there are only 2 persons who could esoterically be on the premises at that date and time. One was Kyle Tyler, who was basically the only person permanently stationed there, and Lloyd Summers, who is the LLC's registered agent. He was never there. And we just want to make sure that the court understands that the process didn't show up on October 11th at almost 12:30-ish, something like that. That didn't happen on that day or any other day. The first time these 2 men saw the papers was on January 12th, when I had them take a look at them and ask if they've ever seen these papers before. They said no. And had they seen them on October 12th, they would have shipped the papers forthwith to Rob Golden, who's the officer of Responsive Service. And as Your Honor has indicated, Civil Rule 4.1A requires a signature, requires the identity of the individual subscribing the document, and it also requires the address. We can all take a look and see what's there. None of those occurred. None of them were there. And Judge, you've indicated, if I could paraphrase you, sir, the signature provision exists to substantiate that someone actually received the summons and complaint. An illegible imprint on the USPS signature line fails to offer us that assurance.
So let me ask you a question.
Yes, ma'am.
Let's say that a person has decided that they're going to try to avoid service by scribbling something illegible. What do we do then? If we find that just an illegible signature is enough to find no service, how do we deal with that?
Well, two things at least. First is the person has to, either the UPS or the scrivener must indicate his or her name. I mean, I have some pretty good lousy signatures, but every time I sign, I put Robert A. Winter Jr. And the second thing is the Postal Service employee must show that the location of where the process was delivered. So you do have that third party intervening to substantiate what was done, notwithstanding the illegible signature.
Okay.
Now,
Right, and I guess my question is, my signature's bad to begin with, but like when I'm signing the credit card receipt things, like I don't even try anymore. I just kind of like do like that. And so if you brought that back to me and said, well, sir, isn't this your signature? I would say, I don't know, right? Like, so what do we do with illegible signatures in this scenario?
the two things I mentioned to Judge Bogg. First, the postal employee has the obligation under the rules to print the name of the scrivener. Second thing, the postal employee is obligated to state where the address of the it occurred. And one thing I didn't put in the brief, put it anyway, you know, most addresses take up two lines, like one will be Post Office Box 5233, and then beneath that, Fort Mitchell, Kentucky. They only made it to the first line.
Seems like the post office might need some training in how to comply with service of process.
Well, if you provide me with $2 million, I'll be glad to put an unsolicited proposal into the post office and see if anybody bites. But again, just to mention, again, the October 11th, 22 date, Mr. Taylor and Mr. Summers indicated that Mr. Summers indicated he wasn't there. Second of all, Mr. Taylor said he was the only one there, and that process didn't show up on that date and time or ever. So that's the upshot of it. We have bad service as a matter of law. I did indicate that if the trial court felt that it was needed some evidence on it, perhaps we should have had hearing, but I don't think so. I mean, that just doesn't get it. So let me reserve my 5 minutes. Thank you, Your Honors.
Thank you. All right, Mr. James.
Yes, good morning, Your Honors.
Good morning.
May it please the court. This is a case about poor postal penmanship, but not about lack of service. As Your Honor noted, your own signature is illegible sometimes when signing credit card receipts. Many signatures we all make nowadays, including with the Postal Service, as we've all experienced, are sometimes on electronic readers now, little phone-sized devices where they hand you a stylus or sometimes tell you to use your finger even. And unfortunately, whatever mark you make is often not legible. But here, what's important for the court to note is the rules were followed. The clerk followed the rules in the trial court. The plaintiff followed the rules in terms of requesting service. And the postal worker actually followed the rules here, too. This is not the case.
I mean, I have trouble seeing how the post office comply with the rules when we can't decipher anything. Like the signature, I kind of understand that, but the address, like we have no indication that this was served in anywhere other than just Atlanta, Georgia.
Your Honor, a few things as to that. There is the tracking number on the return of service. Unfortunately, these returns of certified mail service the post office provides now don't routinely put the address on them, but it can be tracked back to the number that the clerk used to dispatch it. Secondly, the rule does not require the postal worker to actually do anything. The rule requires the clerk of court to give instructions to the postal worker saying do these things. There is no rule saying that a postal green card or the modern equivalent of the electronic receipt is void or nullified in some way if it is not legible and complete.
Right, but if they don't do it in a legible fashion, then the other side can come and say, hey, we didn't get service. And if you have this filled out completely, then that torpedoes that argument.
The post office can mess things up by lack of legibility or other things, certainly. And in fact, the defendants did attempt to set it aside. They used the remedies the court had for that to try to contest this. They didn't
And so why isn't that enough? Why isn't there an affidavit saying, like, there's only 2 people here, or there's only 2 people that could have received this, I'm one of them, I was there that day, I didn't get this, it's not my signature. Like, why is that not enough?
Judge Triggs didn't hold a hearing, of course, so there was not testimony as to all of this. There were affidavits and arguments presented. There was also an earlier motion attempting to set aside the judgment with an affidavit with false facts in it that was withdrawn. A court can determine that it disbelieves the evidence presented in the form of self-serving affidavits from someone trying to set aside judgment, just as if someone, as you noted, Judge Bach earlier, if they were to scribble their signature to try to avoid good service later. The court can choose to disbelieve things such as that, and here Judge Triggs clearly did. It's important to note also that there's case law, of course, saying that a defendant is entitled to have a hearing over something like this, and they've raised that in their brief. But Hamilton County has a local rule about that also, Local Rule 14C, which says that any motion, whether for summary judgment or anything else, if you want a hearing, you do have to take that very difficult step of putting 3 words on there saying, or 2 words, hearing requested. In the first motion that the defendants filed trying to set aside the judgment, the one with the false affidavit that they withdrew, they did request a hearing. Then when they moved later, they did not, nor did they in their reply, nor did the plaintiff in the case, Sanders and Associates, responding to it. So there was no hearing request. The court took in the motions, sat on it for over a month, I think a month and a half after the reply brief was put in by the defendants that didn't request a hearing, and then the court decided the motion on its own. If they had only followed the rules, Local Rule 14C in Hamilton County, they would have been entitled to a hearing, but they chose to waive that for whatever reason. I don't know why they waived that, but they did not submit any requests for that. And so the court was able to make a decision. And case law is clear, a court can choose to disbelieve self-serving affidavits. Here, when you have a record of a motion initially submitted with false facts in it and withdrawn already, and the court presumably carefully parsed through the affidavit, we all learned years ago in the Clinton administration, sometimes you have to carefully parse through statements that are made as to what the meaning of is, or here what the meaning as to there is. This is clearly a suite in a larger complex, just as in the Custom Pro Logistics versus Penn Logistics case, where the court said the certified mail had to get there. It really doesn't matter who signed for it. It's unfortunate if it wasn't someone from the LLC who was being served, but under modern service requirement, what matters is that the process is followed and that delivery is made.
But we don't even know where it was delivered, really. I mean, how are we supposed to look at this and determine where it was delivered?
You use the tracking information the clerk of court provided to the Postal Service, tie that to the tracking number showing delivery occurred, nothing showing any change as to the address there. That's the best we've got, Your Honor, and had they requested a hearing on that, they could have contested that further in the trial court. But the court has modern processes, as the court has put it, for service, which allow delivery through this method. It's also important to note that this is not, of course, an innocent defendant here. This is a defendant where service was attempted at multiple addresses with envelopes that the record clearly show there was a summons and complaint enclosed at the one that went to Mr. Golden's home address that he said in the first affidavit is where service should have occurred. And they were all unclaimed, and then later he affirmed that was his address, and the way they learned about this judgment was he got a postcard at that address. You can't choose to flaunt the court's processes and then say, oh, there's a smudged signature, smudged address, and even though you can track it back using a tracking number, it's just not good enough. The process was followed here. The clerk gave the instructions to the Postal Service. The postal worker, for whatever reason, had terrible penmanship. I can't explain why that is, but they waived an opportunity to contest that at a hearing by presenting further evidence and having their witnesses.
But I don't understand what they would need to show at a hearing that they haven't already established via affidavit.
The court could have chosen to disbelieve Mr. Taylor's affidavit. Mr. Taylor also has...
Well, I mean, you've already suggested that the court did disbelieve it.
The judge did not indicate one way or another.
Right. I mean, we have no finding by the court on this.
Right. It would be helpful if we did. I agree, but it is not
like
necessary under Ohio law. There are holes in the affidavit. Had there been a hearing, I intended to poke those holes, Your Honor. Mr. Taylor basically says no one entered the door of Suite 106, if you parse it out carefully, to bring the mail in there, which this is not in the record, of course, but would have been developed at the hearing. There's a common mailbox in that complex. Mail goes to that normally anyway. Did the mailman knock on the door? Did Mr. Taylor open it and walk out, or someone else in there at the time open it and walk out and standing on the sidewalk on Marietta Street in Atlanta, sign something there and it get overlooked? There are holes in this, and the judge could have chosen to believe this is a self-serving, carefully parsed out affidavit, and they didn't request a hearing. There's a record of dodging service, essentially, by ignoring the mailings that went out and then confirming it was the correct address. So presumably those are factors the court took into account, but I can only say presumably, Your Honors. I don't know. But the key fact is service is good under Ohio law, and they waived the ability they would have had to have a hearing over to further contest it by not requesting one. A simple process. Mr. Glenn Fagan was the attorney at the time. Mr. Winter was working with him. Could have done that, and they didn't. We don't know why. What my client's view here is that this is simply another attempt to subvert the court's processes and delay enforcement of the judgment. I would like to point out also one error in the reply brief, and it's a misunderstanding, I'm sure, but on January 4th, the clerk of court did not reissue service of the summons and complaint to defendant Responsive Surface Technology. There was a garnishment which had been filed 2 weeks before that in December, and for whatever reason, the clerk of court took weeks to actually send it out. But the regular mail service that went to Responsive Surface Technology on January 4th was service of the garnishment, not a summons and complaint. And it's curious in their reply brief that they say it was of the summons and complaint. Did they open it? Is the next question, because it clearly wasn't. And the court's docket makes clear there was a garnishment issued to Truist Bank. Service to it went out on January 4th, and service to the defendant on that same date. I don't understand how they can misstate it was another copy of the summons and complaint then, because it clearly wasn't. There's a question from that as to who's reading their mail, who's answering it, and is anyone really telling the truth here? So, do your honors have other questions?
I don't think so.
Okay, if I may have one moment here. Another factor, and of course this is possibly something that would end up in the trial court if this goes back down there, but a key point is the defendant Responsive Surface Technology actually appeared in the trial court when it filed its first motion to dismiss on December 1st. And then they withdrew it 2 weeks later. And then their next filing was the motion to set aside, which I believe was January 17th, and then they put in an answer on February 8th. But by making that appearance and then withdrawing it, they had appeared in the case, whether they'd been served or not. They clearly had notice as to that as well.
But that came after the default judgment, right?
It did, but by then choosing.
Because otherwise, you wouldn't be able to get a default judgment if they appeared.
Yes, the point in them appearing, Your Honor, is that then they had appeared in the case, they were active in the case, they were arguing they hadn't been properly served, but by submitting themselves to the jurisdiction of the court, the answer they filed should have been filed within 28 days, and it was not. And their next motion to dismiss was not filed 28 days after they appeared either. They waited longer than that. Technically, that's another default. Not something that's been determined, of course, by the trial court, because it doesn't need to be, because there's already a default. But those dates are important too, Your Honor. This is the case of a debtor dodging a debt, and it boils down to that. Any further questions?
Yeah. Thank you.
Thank you, Your Honor. Your Honor.
All right, Mr. Winter, you have your rebuttal time.
Just a couple of points, judges. First, we can't blame the failure of compliance with the civil rules based on electronic technology. The technology has to keep up with the rules, whether we like them or not.
I think the old rule is better because you could actually read the little green card and tell if somebody signed it. I looked for it, I couldn't find it. It's not there.
They say that the post office didn't have to comply with the rule, but if you take a look at paragraph 10 of the CUC Properties case, the court made it very clear that it's the obligation upon the post office to get the signature, identify the scrivener, and state the location, as well as the date, which was done here. There was a subsequent process that was issued by Mr. James to my client. As it turned out, that process was sent to Suite 106 in Atlanta, not 105. And then once that came back, we had service submitted to 105, and let's just get rest in the case, and it's before the court, and that's what we would ask this court to vacate the default judgment. Let's litigate this on the merits, for better, for worse, for rest, and we would ask that you vacate the default judgment. Thank you, judges, for your time.
Thank you. Thank you both for your arguments today. The case will be submitted, and we'll get out a timely written decision. Hope you both have a great day.
Did we have this before? Were you on the panel? Next case? Okay. All right, there's something else.
I think I was.
Maybe you were. Okay. Okay. I remember it. Okay.
Mr. Goldwasser, let me step forward. Would you like to reserve any time for rebuttal?
Sure. 7 minutes.
I'll let you reserve 5.
Okay. My main argument's going to be about as long as my brief.
Yeah, it was short.
It was.
You may proceed.
Morning, Your Honors, and may it please the court. Louis Schnatter on behalf of appellant Darren Moorman. Procedurally, this case is kind of taken a circuitous way to get here. It was filed under a straight negligence claim against one of the defendants, two technically the defendants, but not defendant Livanova, then dismissed without prejudice. When it was refiled, it was actually removed up to federal court and then worked its way into a multi-district litigation and then remanded back here to the common pleas. There was a motion to dismiss filed. That motion to dismiss was denied under 12b-6. There was a case law in a companion case to this that actually came out from the First District Court of Appeals that basically said the type of complaint that I had drafted and filed in this case was sufficient to withstand 12b-6. So we went and had a scheduling conference with the court's assistant down in the trial courts. You usually don't meet with the judges for scheduling, kind of the standard discovery order that Hamilton County most judges kind of use. And we set forth dates, got a trial date, discovery dates, all those things. And at that time, I believe it was Mr. Goldwasser and his client objected to discovery taking place, and they said, we want to talk to the judge about it. But nonetheless, the scheduling order went on. And shortly after that, I believe they filed a motion basically to modify the scheduling order because they said, we don't want to participate in discovery until the plaintiff affirmatively produces some evidence that there's causation here. And we objected and said, we don't have to do that. Plaintiff does not have to do that in this type of case. There's no other case in Hamilton County where that's required. Under Ohio law, you've got Rule 10D. Like in a medical case, you've got to file an affidavit of merit. This isn't a medical case. This is a products liability case. There's thousands of products liability cases that are filed in the state of Ohio every year. Procedurally, it's inappropriate to require that out of a plaintiff when the discovery has been set and discovery is needed in order to...
Well, let me ask you about that. Like you say discovery is needed.
Yes.
Was there any pending motion to compel or anything that you could point to that would say, we absolutely needed this information before our expert could draw some conclusion on these issues?
No. So under Rule 26 and then obviously Rule, the 30s, like Rule 37, in order to begin that, you would actually have to be able to, serve discovery and have discovery put forth in front of the court. We did not make any affirmative motions with the court saying, please provide us this discovery. What we argued, and I argued, and I don't want to say incessantly, but repeatedly to the trial court judge during these status hearings that we would have, was that we need this information. We need to be able to conduct normal discovery.
But what information? That's what I'm asking you.
Yeah, so if you take a look at the expert report that was
Right.
filed, it was like a one-page letter
Right.
from Dr. Jarvis. And Dr. Jarvis is not some, I don't want to say hack off the street or anything else like that. I don't want to call him the real deal, but he is a expert in this particular product causing these particular types of infections. And what he said in his report is, I need information from Tri-Health Hospital to determine how many, what levels of infections they were having, the history of infection, the product, all these different things, and I'll be able to connect that with what Mr. Warman's got going.
But I thought he wasn't even confident that Mr. Warman had this infection.
There's nothing saying in here that's saying he's confident he has it or confident he doesn't have it. The problem with the Mycobacteria camara infection, and the appellees will disagree all day long with me on this, but the problem with the Mycobacterium camara infection, and it's actually included in the a letter that Tri-Health sends out to everybody, as well as what Dr. Jarvis says, it's very difficult to diagnose. The symptoms of it are very difficult to diagnose. So what Dr. Jarvis wanted is to see what exactly he was exposed to and what levels of Mycobacteria camara they had in their operating suite where this guy had his surgery, because they're sending out a notice saying, hey, you may be exposed to that. And at that point, he would or would not be able to connect it after he got that information.
But I guess I'm just having trouble, and forgive my lack of medical knowledge here, but if I'm a patient plaintiff and I say I've been injured somehow, I either have or I haven't, and would the expert not be able to say, you have this infection, you don't have this infection, you've got these symptoms, you don't have these symptoms? Like, how is that not the case?
With a normal type of infection, that is the case. However, because of this weird infection in these particular types of cases, with this particular type of equipment, that's not necessarily the case here.
Okay.
And that's what Dr. Jarvis basically said, you know, this is a weird infection. It's called chimera, as in terms of, you know, like some sort of Greek monster or something that changed. It had 3 heads, and it was like a goat, a snake, and a lion.
My mythology's a little rusty, but.
Yeah, mine as well. But there's a reason it's caused that. It's difficult to diagnose. They're going to say, oh, no, it's super easy to diagnose. We have a dispute about that, but that's a factual dispute that ought to be worked out in the trial court. But from a procedural standpoint, it was inappropriate for the trial court judge just to say, oh, nope, you don't get discovery on it, even though there's no undue showing of burden on the defense. In other words, they didn't present anything under Rule 26 to say, hey, this is overly oppressive. And new Rule 26.
But I thought you just said you hadn't served anything under Rule 26.
Exactly.
Well, but like, I guess I don't understand how, if you're saying, gosh, we really needed this other information, this information was critical to our expert rendering an opinion, then why hadn't you requested information?
The judge instructed us not to do any discovery at all. So.
The judge forbid you from doing discovery?
Yes. Yeah, and I'm not sure if that's not clear to this appellate panel, but the judge said no discovery until you get an expert report in. That's the issue in this case.
But did you file anything saying, you know, hey, trial court, my expert cannot make this determination until we get X, Y, and Z?
No, Your Honor, we did not. Because we went and talked to the judge and we explained that to the judge, and the judge said, no, I put an order on saying you don't get to conduct discovery until you produce an expert report establishing causation. So no, we didn't file a motion with the court to say, please reconsider your ruling, where she was very explicit with me that we were not to conduct discovery. When we went back and saw her, she said, if you don't do this, you know, that's it. And I said the entire time, I was like, Your Honor, this is not fair. As a plaintiff under the civil rules, we should be allowed the opportunity to conduct discovery, whether it be limited discovery, whether it be full discovery. We should have the opportunity to conduct discovery. And the trial court repeatedly said no, even after a case scheduling order was put on that allowed for discovery and said, hey, you have until July 2023 to conduct discovery. And at that point, like I said, the appellees filed motions basically say, we don't want any discovery on this issue. Make him produce an expert report first. And I've told this to the judge, you're basically putting the cart in front of the horse, because according to my doctor, according to the development of this case, we need information that the defendant has, and the defendant has a lot. Both defendants have a ton of information about Mycobacterium infections, Mycobacterium chimera infections, and the use of this equipment in their hospital.
Let me ask you a question about that. This bacteria is obviously not reflected in your client's medical records. So how would your expert connect this bacteria to your client via this machine?
Symptoms, and the type of symptoms they
Wouldn't
have.
those be in his medical records, though? Would those be in his medical records?
Symptoms would be in his medical records, but in order for a medical doctor to say, hey, more likely than not, I need this information the defendants have to have a solid footing to say, oh yeah, this guy got exposed to it and he's having these types of symptoms. And even though there's no mention of a specific type of Mycobacterium chimera infection in his records, more likely than not, he had it and has it.
Okay. All right. You wouldn't have to go to the extent of exhuming.
Oh, he's still alive.
Oh, I thought he died.
Oh, no. Mr. Warman's still alive. I've got a companion case
That's what I was
where...
thinking. Yeah, because you were here before, right? Okay, that's what I was thinking.
I was, Your Honor. That's Mr. Napier, and he's dead.
Okay, right,
And
sorry.
he died like a month.
Oh, I'm sorry. Okay, so your client's alive. Couldn't a doctor diagnose him, or, I don't know, I'm like Judge Bergeron, I'm not a medical expert. Couldn't they take a blood test or samples or something to determine whether he has this or not?
I don't think they can, but obviously
Okay,
that's up for the defendants to point out. What I'm saying is my expert, who's he's, like I said, he's a very good expert on this, says I need this information in order to conclude, my diagnosis or to conclude my opinion. I don't have it. So.
But what the doctor also said, that he said he was in the process of reviewing the medical records, rather than I've reviewed the medical records and I need X, Y, and Z. I mean, wouldn't it have been better for you to submit this earlier and showing it to the trial court and saying, you know, we cannot continue, or I cannot get a complete diagnosis or an opinion on causation until I get this information, which seems pretty general. But he said that he needed information about these devices that they were using. But wouldn't it have been better to present it earlier rather than?
It definitely would have been better to present it earlier. At the same time, I believe it was in one of the earlier status conferences where we had with the judge, I explained to the judge, hey, we need this stuff, and she said, no.
Is that on, I mean, is there a transcript of that conversation?
There's a transcript of it. I don't know if I specifically asked for the words that were in there, but I basically informed the judge, hey, my guy needs discovery. We need to be able to conduct discovery.
But you didn't file any sort of written motion?
No, I absolutely did not file any sort of written motion with the trial court. Because as I'd said, it had been explained to me by the trial court judge multiple times that we were not going to have discovery on this issue. That basically what I needed to do was my expert needed to take the information that I had when I filed the complaint and go ahead and create an expert report that satisfied the judge's, I guess, requirements. And what's weird about the judge's requirements is they were pretty general. Nonetheless, it's not appropriate. There's nothing under Rule 26, Rule 37, local rules, or anything else like that this case should be treated any differently than any other case, especially if after it already survived a 12B6 motion.
Right. So you're at your time if you want to reserve time for rebuttal.
Yes, Your Honor.
Okay, thank you.
Thank you.
Good morning.
Brian Goldwasser on behalf of
Yeah.
TriHealth.
And you all are sharing time, is that right?
We are, Your Honor. We're going to try to split it as equally as possible.
Okay.
So I'll try to pay attention to,
Well, I can give you a heads up.
would you mind,
Not at all.
8 minutes in, I suppose?
Sure.
We need to start at the beginning of this case, Your Honor, and before a lawyer files a lawsuit, a lawyer is obligated under Rule 11 to do a reasonable investigation as to whether there's merits to a case. And that doesn't necessarily mean being able to always prove every element, but there has to be a reasonable basis. One of those is, does my client actually have an injury? And if he does have that injury, is that this Mycobacterium chimera? Our briefs discuss it in some detail, but essentially what Mycobacterium chimera is a very, very rare bacteria that can occur through aerosolization. Mr. Weinbreger could probably speak further to it since he's the product manufacturer. But in essence, what occurred in the mid-2010 timeframe was there was a very rare occasion where a mycobacterium would appear in a patient who underwent heart surgery after one of the heater cooler devices were used. In 2020, TriHealth, late 2019, TriHealth became aware of one instance where an individual had been diagnosed with chimera and sent letters out to 1,300 individuals saying, we have one case where someone has it, and if you have certain symptoms, and they outline the symptoms, please contact us.
And there's some issue about the latency period, right?
There is a latency period, yes, that's right. In fact, Dr. Jarvis, whose frankly report should not even be considered by this court because it was filed after the case was dismissed, even says in there it's a 5 to 7 year latency period. We submitted a report from Keith Armitage, who's an infectious disease expert, and submitted that early on in the case that shows that Mr. Warman does not have chimera because he doesn't have the certain symptoms that one would have. And, Your Honors, as Judge Winkler pointed out, it would be in the medical records that there would be some evidence of certain types of symptoms that would justify further investigation. That is not something that requires detailed discovery in terms of what specific heater cooler number was used, what happened in this particular operating suite, if that could even be determined, because it was 5 to 7 years or longer earlier. This gentleman underwent surgery in July 2015. By the time this case came before Judge Lubers, this was already 7 years later. It was not difficult to look at the medical records, have it reviewed by a competent, credible infectious disease specialist, and say whether or not there's even a reason to consider that this individual has this particular bacteria or may have certain symptoms that require additional studies. All that needed to be done by Mr. Schneider and his client and his expert would have been to have a culture taken, because he is still alive, and determine whether or not he has that. That was never done. When we came before Judge Lubers, we asked the court from the beginning to have Mr. Schneider prove to us a reasonable basis that this individual has chimera. Before we do anything else, before we even make a determination whether the chimera is related to this particular product, show us you have chimera. Judge Lubers agreed, and that was a reasonable exercise of her judicial discretion to say, okay, that makes sense to me. Before we go down the rabbit hole of going through a significant amount of discovery against a product manufacturer, significant discovery against a hospital, you, Mr. Schneider, show us something that says he has chimera. We do have transcripts, Your Honor, you pointed out the transcripts. There is an October transcript and a December transcript that are part of the record. Those were filed early on in the case. In the October transcript, Judge Lubers said, look, you have 60 days to show us some evidence that your client has chimera. If you cannot do that, come back, give me a detailed explanation in writing of what your expert needs. Give me the A, B, C, Ds, et cetera, as to what happened. We came back and said, and if you don't, I'm dismissing this case. We came back.
Was that, is what you're referring to, is that in a written entry, or was that the transcript?
That was the transcript, Your Honor. We cited to it in our brief, but that was the October 11, I believe, transcript. And we then go on to December, where Mr. Schneider returns and says, no, I don't have a report. No, I don't have any evidence. No, I need more time. Over our objection, the court said, fine, I'm going to give you 60 more days. That actually turned into March 3, so 90 days. And she said very clearly, she said, Counselor, if at the time of the hearing, 1:30 p.m., you do not have evidence that your client has developed Mycobacterium chimera, your case will be dismissed. There was adequate warning. There was adequate time provided. Mr. Schneider did not appear. Attempts were made by the court to contact him. There was no response. Mr. Weinbrenner was available by Zoom. Since he's out of town, I was present in the courtroom. This is all in the transcript. And Judge Lubers said, fine, there's no evidence, the case is dismissed. We believe, Your Honor, that the court properly exercised its judicial discretion as to how to manage its docket, which way to look at what was the most efficient and economical way to address issues. And if Mr. Schneider or his client could never prove to this court's satisfaction, by way of an expert, that there was chimera that this gentleman had, the case would be dismissed, and that's what the court did. I'm trying to split my time here, so unless the court has anything further of me.
You're right at 7.5 minutes. So
Wow, look at that. All right. Thank you, Your Honor.
Morning.
Good morning, Your Honors. Joe Weinbrenner on behalf of LivaNova. LivaNova joins in the remarks of Mr. Goldwasser and TriHealth, and I will add a little bit of additional flavor, being counsel for LivaNova, who manufactured and designed the 3T system. This is one of more than 200 cases that have been filed across the United States involving the 3T system. This is a piece of medical equipment that's used in open heart surgery. It regulates the temperature of the patient's blood during the procedure and of the cardioplegia solution that is used to stop the heart to enable the surgery. It operates based on water. There are 3 tanks within the device. The allegation that underlies these cases is that there is a very small amount of water that aerosolizes from the machine and into the operating room, And if there is contamination above a certain threshold in the water with what is known as non-tuberculous mycobacteria, or NTM, of which M. chimera is one type, then there is a chance that the pathogen can be transported into the operating room through these aerosols. So that is the allegation that underlies all of these cases. And the common thread that connects these cases is an allegation and proof that the plaintiffs have actually sustained an NTM infection of some sort. M. chimera, Mycobacteria abscessus, whatever the case may be, the allegation is that the plaintiff has actually sustained this infection. And this infection is one that is detectable. There are blood cultures, there are tissue cultures that are performed. This evidence is frequently, in almost every case, a part of plaintiff's proofs. This is found commonly in the medical records. In the rare instance where a plaintiff's claim is valid or allowed to proceed and there isn't a positive culture, there is a diagnosis. There is a physician who has diagnosed an M. chimera or other non-tuberculous mycobacteria infection.
So could there, under your view of the world, could there be a situation in which the expert evaluates the patient and says, I'm seeing some symptoms, it's not completely clear, I need some additional information to finalize my diagnosis?
Not from the manufacturer of the 3T. It is a medical opinion. This is a medical opinion that, based on medical records, based on medical tests that are performed, based on symptoms that are exhibited by the plaintiff, that can be diagnosed. And that is what we've seen in these cases. There's no liability discovery that is required of LivaNova or of the hospital that has any bearing whatsoever on whether Mr. Warman did or did not have a Mycobacteria chimera infection. Now, plaintiff in this case, Mr. Warman, has affirmatively alleged, not once, but in 3 separate complaints over the course of now nearly 3 years. He has affirmatively alleged that he sustained an M. chimera infection. And ordinarily, in that circumstance, there is some reasonable basis that the plaintiff will have sustained an M. chimera infection. Now, early on in this case, after it was remanded from federal court, it became very apparent that plaintiff did not have that reasonable basis. There was no evidence in the medical records of an NTM infection. And during the October hearing, the court specifically asked Mr.
And when
Schneider,
was the defense expert report filed?
The defense expert report was from Mr. Goldwasser, and I believe that was the December of 2022. Now, the court specifically asked Mr. Schneider whether he could say that his client had an M. chimera infection, which was alleged in the complaint, and he acknowledged that he could not. That, in that circumstance, fully justifies the court's order to procure that evidence in order to proceed. Now, this is a early proof of a claimed injury is a case management strategy that is common in the context of mass tort cases.
I mean, it's more common on the federal side where you've got different discovery requirements and options for MDL litigation that we don't have here in Ohio.
So I will acknowledge that mass tort cases and consolidated litigations are more common, they are more frequent in federal court. But the underlying procedural rules that provide trial courts discretion to sequence and to phase discovery in this way are equally available in the state courts here in Ohio. And it's certainly our submission that the trial court here was well within its discretion in exercising that discretion and requiring plaintiff to produce this evidence, particularly in light of the admission that he did not have evidence to back up the affirmative allegations in his complaint. Now, another characteristic of this litigation that made this order particularly appropriate is the signature type disease, the signature type injury that is associated with the 3T system. It is an NTM infection. And plaintiff affirmatively alleged an M. chimera infection. It's a very particular bacteria. It is exceedingly rare. Even in hospitals that have reported cases, it is still exceedingly rare. Now, infections happen all the time in the context of cardiac surgery, but not with M. chimera, not with non-tuberculous mycobacteria.
And sorry to jump from the science to the rules of procedure, but are you taking the position that Lone Pine orders of the nature that was implemented here are always permissible for trial courts to use, or what is the rule that you're espousing?
Well, I wouldn't say that it's that Lone Pine orders, which is the type of order that we would say was entered here, are always permissible. But the trial court does have the discretion to enter these orders.
And so I guess that's what I'm getting at is, like, what are the circumstances? Because if they were always permissible, there's the concern that you're basically inverting the summary judgment rules. And so my question is, what are the circumstances that should limit a trial court's discretion in deciding whether or not to implement an order like this?
Well, here I would say that there are two critical features that made it permissible and particularly appropriate here. One is the signature type disease. It's black and white. He did or did not have the alleged disease. He affirmatively alleged it in the complaint. And then the second feature is that it became apparent very early on that there was zero evidence of this infection in the medical records.
Well, I thought that, okay, so the incubation period is 5 to 7 years, but are these, I mean, your opponent is saying that these infections are very difficult to diagnose, but you're saying that it's easy?
Well, they're commonly detected by culture, blood culture, tissue culture. It's acid-fast bacilli is the type of culture that is run. It is run on tissue and blood. If it is a positive culture, then NTM is present. There are additional tests that can be run to determine the specific pathogen, the specific mycobacteria that's at issue, whether it's M. chimera, M. abscessus, or another form. But it is a standard culture that is run when this type of infection is even remotely suspected.
Well, I mean, are there false negatives, though?
There may be false negatives. There may be false negatives. I think that the critical feature here, though, is that there's no evidence. So there was an affirmative allegation in the complaint, not one, but 3 complaints. And there was no medical evidence at all to back it up. And so in those circumstances where the question of whether Mr. Warman did or did not have an M. chimera infection is something that can be determined from review of the medical records or a physical examination or additional testing that plaintiff's expert may want to perform, that is something that we submit is fully appropriate at the early stage of this case. Plaintiff was given plenty of time to comply with this requirement. Initially 60 days, he asked for an additional 60 days and was given an additional 3 months. So he had a total of 5 months. He was put on notice at the very onset that if he did not produce this evidence, his case would be dismissed.
And you are at your time.
Thank you. Thank you, Your Honors.
Thank you. All right, Mr. Schneider, you have 5 minutes for rebuttal.
It appears that the appellant and appellee disagree a lot on the science, but obviously that comes back to a factual thing. Procedurally, I don't think appellant and appellee disagree on what happened procedurally, which is essentially, and he mentioned Lone Pine orders. This was a Lone Pine order, basically, that Judge Lubers decided to make, or the trial court judge, I apologize, that the trial court judge decided to make. There's no precedent in Ohio for this, and it can set a very bad precedent in terms of what Ohio civil discovery allows for, what the rules allow for, what is required. This isn't an MDL. The trial courts of Hamilton County are not a multi-district litigation.
Well, we understand that. But you had the defense expert report, like you had that. So this isn't a case where they're making allegations and they're not kind of backing something up. They've said, look, here is what a diagnosis would look like. We don't see any of this from the medical records. So like you already had their view of the case. And then your guy really can't come up with an opinion.
My guy wants information in order to come up with an opinion.
But I guess I get back to specifically what information would he need that would render him capable of rendering an opinion that he's not able to do right now?
From his review of the medical records, in addition to that, he wants the information about the M. chimera or the type of bacteria that was in that particular operating room that Mr. Warman underwent surgery in. So that's what he wants.
But how, I mean, just, and I think I've asked you this before. But,
yes.
But humor me. Whether there was M. chimera in the operating room or not, I don't understand how that impacts the expert's opinion of whether it is present or has infected your client or not.
According to my expert, he would feel he would be able to provide an opinion after the review of that information. And if he's like, look, there's not enough M. chimera, there's no evidence of M. chimera, during this time period, thumbs down. Yes, evidence of it based on these medical records and based on the information that I've got regarding where he had surgery, I'm giving you the green light. I'm gonna be comfortable saying it's more likely than not.
But then you're in a position where you've not only filed a complaint, but you've litigated this and gone through this process, and you don't even know if your client's been damaged.
There's a bunch of medical treatment that he's had. I mean, there is medical treatment that he's had for these types of symptoms, for this type of stuff. Now, we got one expert disagreeing with another expert. That's a fact issue that can go to a jury, but we're not even there yet because, unfortunately, the trial court judge basically shortcut discovery on this. And that's really what this is about. It's not about who's going to win and who's going to lose. It's about whether or not the trial court judge abused her discretion or made a bad call or committed reversible error by saying you do not get to conduct any discovery in this case. And that's really what my appeal is about, which is, okay, I could be wrong about this. I could lose. I could lose at summary judgment. I could lose at the trial court. But we're not there yet. I could lose on directed verdict, but we're not there yet. I survive a 12B6 motion saying, hey, I've properly pled this, but now I don't want to say out of nowhere, but essentially out of nowhere, out of no civil rule or precedent that basically says, hey, you've got to do this in this particular type of case. This isn't a medical negligence case. I don't need an affidavit of merit. I have filed a lot of medical negligence cases. I'm more than capable in understanding that I need to get a Rule 10 affidavit of merit. That's not here. So that's the error. That's the very specific error that this trial court committed, which is she basically said, you don't get discovery. Your expert said, I said, my expert needs it. She said, nope, you don't get discovery. Come in with a causation opinion. If you don't get it, your case is thrown out. And she threw out my case. And she didn't just throw it out. She threw it out with prejudice. My client has no recourse, even though he did everything he was supposed to do. He filed a complaint. He's following the civil rules. Not allowed to conduct any type of discovery that my expert says that he needs. Your Honors, I would ask you to reverse the trial court's ruling on this, allow for some discovery in this case, and allow this case to proceed as it should under the Ohio Rules of Civil Procedure and not have my client singled out on this to his prejudice. Thank you very much.
Thank you. Thank you all for your arguments today. The case will be submitted. We'll get out a timely written decision, and everyone has a great day.
You don't have to wait on me here. Too much junk. Oh, thanks.